Aditya, before we begin, I would like to ask you, rather share with the participants your journey in litigation.
Okay, sure. So firstly, my gratitude to Klee and to all the members and even all the participants here for this opportunity. As regards my journey in law, in terms of the council, I basically joined Mr. Dwarkadas's chamber in 2008, spent a good decade in his chamber, moved on to my own private practice. One thing I'll say here, because I don't know how many students would be aware of this, is that when you devil under a senior on the original side, that is the original side of the High Court, you basically still do your own work, but you assist the senior. So in that sense, you could even be appearing against your senior. I have had the opportunity in that sense where I have appeared against him. I have also had the opportunity where I was briefed in a sense against him, where in his chambers we would have one conference in the juniors room where I would be for one side and he would be for the other side in his cabin. But that's how the original side works, and it's a great learning experience. So if any one of y'all is looking to join council practice, joining a seniors chamber is something you must do at some point in time. With that, and with your permission, Malvika, I'll go ahead to the topic for the day,
Yes,
which
please.
is,
Thank you.
which is basically how to prepare your arguments before you get into court. Basically, what I propose to talk about and try or endeavor to explain is the period between when someone hands you a brief or a case till the moment you actually get into the court to do your oral advocacy. In fact, my senior had told me that 90% of a case is won during this period. It is only the last 10% that takes place in court. So, actually, what you see in court or the oral advocacy is sort of the tip of the iceberg, which comes on the basis of all the hard work and all the preparation that is done earlier. Now, when I say from the time a case is handed to you, if you're working in a law firm or you're doing a solicitor practice, the case may come to you in the sense that the client comes with the papers and then you draft and you go ahead. As a counsel, it comes to you fairly often once it is drafted and people want you to appear, or sometimes it comes to you before in terms of advice and strategy. I am going to be talking predominantly from the stage, sort of the papers are ready, and it's come to you now to prepare as to how you're going to argue it in court. A lot of what I'm saying may also help in the earlier stage of actual drafting, but I'm not going to concentrate on drafting in that sense. Now, when we look at this stage, that is from the time a brief is handed to you till you get into court to orally argue your case, I am again going to take it as a given that you would know and you understand that there has to be complete sort of, you must master your facts and you must master the relevant law, or at least know the relevant law to the extent possible. These are sort of givens and there are no excuses or no sort of shortcuts in this area. It is in this context and how to kind of approach a brief, what you should look at is where I'm going to try and endeavor to share a few practical insights rather than go into substantive law or anything of that sort. Now, the first thing that I said, mastering your facts is a given. Here, I think that's clear enough that you must know your facts, but what it also means is that you must know the record. That is the record as it exists in court, because very often a judge will ask you that where can I find this document or where is this averment made? And fair enough, it's not a memory test, but you need to know where it is so that you can point it out to the judge. And as you will find, judges at times can be impatient, at times are patient, but you need to have the answer ready. So when I say know your facts or master your facts, it means knowing what your factual case is as much as knowing where in the record to find it. To give an example, there was a matter that I once did, extremely high stakes, where I was led or by 10 seniors above me. So I was the 11th counsel briefed in that matter, and the record was voluminous. And honestly, it was like me and one junior from the attorney's office. Only two of us pretty much knew what was where in the record. So as a result, every senior up in the chain would call us whenever they needed to find some averment or something while preparation was going on, which helped us because as juniors we had the time to know and keep a track of the record. Now, going beyond that, in terms of how do you approach and how do you look to prepare to get ready for arguments? Again, I'm going to take a quote from Mr. Dwarkadas in a speech that he gave on advocacy. He said that the most principal thing that you need when in advocacy or when you want to make a good argument is anticipation, anticipation, anticipation. And that is what I am going to commend to you also, which is that when you read a brief, you read it as much to see what are your good points and what you will argue and which are the points that you will sort of try and push in the court. But equally, if not more important, is anticipation in terms of anticipating what your opponent might argue or even anticipating what the judge will ask you. And it's very important that you bear this in mind because your case, the other side is going to know, the judge is going to hear you, but it is beyond that. That is, you have to be in a position to answer what the other side will say. You have to be in a position to answer what the judge's queries will be. And yes, we may say thinking on your feet, court craft, that for the queries you could not anticipate, but you must make that effort to anticipate as much as you can. And a large part of time, according to me, in the preparatory stage goes in thinking and sort of continuously thinking, what would I argue if I was on the other side? So it's always a constant sort of scrutiny within to think that if I was on the other side, how would I argue this? Or if I was the judge, how would I look at this matter? Would I look at it the way Mr. So and so is trying to tell me, or would I look at it differently? Try and place yourself in the shoes of the judge. Would he accept, would you accept the argument that you're trying to make in the given facts? Or would you look at it differently? If you would look at it differently, why? What answers can you prepare for that? According to me, this is one of the most important parts of preparing from the time you get your brief till you get into court. That is anticipation and sort of getting ready to answer what may come your way in court. In this context, one more factor that I would highlight is that I have seen a lot of time people sort of cite judgments and or they find one judgment and they don't really look up law beyond that. So an advocate will walk into court and say that I am covered by so and so case and really have no backup argument or nothing. Now, fair enough. At times there are cases which are straightforward covered, but you must also have prepared in terms of anticipation that if you could find this case or that case that easily, your opponent also knows about it. And your opponent is getting a fee to defend. He's not going to come there and take it sitting down. He is obviously going to try and come with answers. He's going to try and distinguish your judgment. Or for what it's worth, even the judge may tell you that, look, that case was an exception. Your facts are different. Therefore, when you cite case law, you need to make sure that it is factually sort of on all fours with your case. If not, you must be ready with why it would apply, the principles would apply in your case. And here, I'll sort of take a step back to just address a point that I feel these days is a little missing in the legal fraternity, especially in the junior members, is that we tend to start looking for a proposition directly in case law. The habit of reading a commentary or a book on the subject is dwindling. I feel personally that it is very important to read the commentaries or the books to get an idea of how the law has been interpreted over the years and how it has been evolved. If you have a basic understanding of that subject and the law, then go directly to the case law because the case law will help refine or fine tune that knowledge. But if you don't have a basic understanding, then I personally feel that reading case law directly is not always helpful and it doesn't buttress your understanding. You may well get a lot of information from the case law, but I do not believe it translates into understanding and then knowledge. So I would suggest and commend that at least for new areas, you read a book, the commentary, get a feel of the law, how it evolved, and then move to case law. So this in terms of anticipation and being ready to meet whatever is thrown your way in court. The second aspect that I would highlight, sort of to say during this period, is now coming to your case. So first try and anticipate. You've read your brief, you know your basic points, what you want to argue. You've anticipated what the other side could argue. You've anticipated what the judge may tell you. Now, based on those factors, formulate your arguments or your submissions so that when you get into court, you can tell a judge that, look, my case is pegged on these three submissions or these two submissions, and try and identify the propositions or the submissions you want to make so that it's easier for a judge also to note or understand what is the point you're making. Of course, you may add to that point in terms of material or details, but at least sort of make a proposition that you can give to a court. Here, I would say two or three factors. One, formulate your thoughts with some clarity to come to some basic propositions that you want to tell the court on the basis of which you should be entitled to the reliefs that you seek. These propositions, according to me, should be simple and something that a court would accept in that sense, because that is what you're trying to do. Your idea when you get into court effect eventually is basically to convince or communicate to the court that why your case or your viewpoint is the correct viewpoint and why you are entitled to the reliefs that you so seek. Therefore, it is very important that you formulate the propositions on which you seek to get those reliefs with some clarity. In fact, according to me, this period, when you're preparing, you may read 20 judgments or 30 judgments to decipher one proposition. That does not mean that you get into court and cite all 30 judgments. The idea of the extensive reading in this period is really to refine and fine tune your research and your submissions. So there could be times where you read 30 judgments only to reject 29 of them, or maybe even all 30 and sit back and look for one more, which will help buttress your case in court. So don't ever think that just because I have read 30 judgments, I have to cite all 30. The point is to cite, sorry, let me clarify. I'm not saying that you suppress law which is against you. The idea is only that you cite relevant law, but try and keep your submissions simple to that extent. Not every matter is a constitutional matter which requires 30 judgments. Even for a judge, think about it from the judge's perspective. He's got a full board to hear through the day. If, of course, if your matter is complex, no judge is ever going to stop you from citing law or from arguing it. But if it's a simple point, then there is no reason to complicate it. Another way of looking at it could be to say that, look, if you feel that according to me it's simple, but what if the judge thinks it's complex and asks me 20 judgments or asks me 20 questions? Fair enough. Go in trying to maybe say that it's a simple point and this is how I would like to address it. If the judge asks you, but what about this? Then, yes, go ahead and show him the judgments that you've read which address the point. But unless necessary, you may not need to get into all those details in every matter. Some matters, yes, but not all. I give an example here of a matter that I had actually seen. So, when a court passes an order, there is a procedure to correct if there is a clerical error in the order, basically typographical errors or things like that. The CPC recognizes it in section 152, if I'm not mistaken. And in the High Court rules, we basically call it speaking to the minutes. Now, I still remember, now speaking to the minutes is something which is done regularly because typographical errors do take place. It's a human element. I remember a junior once coming to court and trying to argue or speaking to the minutes application by starting to say that my application is under rule so and so of the High Court rules. It is for speaking to the minutes. Rule so and so reads as under. And the judge got really impatient, saying that, look, I'm not concerned with the theory. I know this is my power. Just tell me what is the correction you want. Now, that's what I'm trying to say, that just because you have read 20 things doesn't mean you have to go there and show the judge that I have read 20 things. It is for you to know that you have read 20 things. And if the judge questions you, then you bring it out. But I don't think it is something when you're formulating your submissions that you have to think that I have to go and show all 20. Another way I like to look at it personally is I always tell myself this, that my job as a counsel, in a sense, is to try and communicate to the court why my viewpoint is correct or why my client's viewpoint is correct. If I can do that in a simplistic way, then I would prefer that rather than me getting that done by citing 20 judgments and getting a reported judgment in my favor. Being there's no harm in a reported judgment, but if it can be done in a simpler way, then really the end purpose is to try and communicate and get a decision in your favor. So you have to weigh sort of the balance when you get to this stage. But the point I'm trying to make is only this, that formulate your submissions, keep them clear, sort of um, well planned in that sense, and try and keep it simple to the extent possible. The next thing, test your submissions. Always test your submissions in the sense, again, this is sort of a facet of anticipation, which is whatever submissions you're planning to make, test them, take them to their logical conclusion. If this was applied in some other case, if this proposition that you're making was applied in a different set of facts, would it apply? Or would it have a disastrous result? Because the judge is going to think of all that. So you need to think ahead with your argument that if this argument is accepted, what would be its effect? And that is another aspect which we call basically test your arguments by taking it to its logical conclusion. Here in the beginning years, I think it's extremely helpful to even discuss with your colleagues or chamber colleagues or friends at the bar, because sometimes points that you may miss, your friends may bring back and tell you, makes you sort of think a little harder. And at least in the initial stages, I think it's really helpful to be able to discuss it with friends, colleagues, things like that. Another question or another exercise that you do with your submissions is sort of take a step back. Once you've prepared, take a step back, try and look at the bigger picture. Because for a judge, eventually he is deciding in equity, justice, and good conscience. So, whilst the law and the strict or plain language of the law applies, there will be many a time where the judge may feel that the plain language and the equity are different, and he may try to balance the two. So, therefore, always try and take a step back and look at the bigger picture also, and whether what you are arguing will be in sync with what the court will think or will be in sync with sort of the bigger picture and the equity of the whole case. One last point that I'd make on this aspect is that when you're preparing, also think about sort of the ramifications of your argument, about if it is accepted as it is, what would it mean? And then base your submissions on that and go ahead. Now, coming to another aspect that you have to do at this stage, especially if you're going to be arguing the matter or maybe even assisting a senior, is making your own notes. Like I said, I'm trying to only endeavor to highlight the practical issues that arise, because notes or making your own notes on how to argue in court, according to me, is an extremely important element which we tend not to realize until we've had the experience of going through a few matters in court and our notes sort of being called up. The reason I say this is this, that if you make notes which are too verbose, then when a judge asks you a query, you may find it very hard to find exactly where you have written that particular point or refer to it in your notes. And you may lose time trying to find it. Alternatively, make them too short and you may not have even written the point that the judge is referring to. Of course, if you have with experience learned to anticipate everything that a judge may ask you, you should pretty much have everything in your notes and you should know what he is likely to ask you. But to be honest, that comes with time. It takes some amount of experience to realize that, not only in terms of the substantive law, in the sense that in this branch of law, these are the kind of questions I may get asked, but even in terms of a particular judge, because there is always a human element in our profession where each judge may look at a given case differently. So you kind of learn even to read judges over time, that this judge will ask me these kind of questions, or this judge will probably ask me that. So I should know where it is and I should have this written down. So that's a very important aspect of preparing your notes. And I think it takes time to sort of figure out and come down to your format or a flow that you find comfortable to your practice. One thing here I would mention is that when I say notes, I do not mean that you write down a speech that you're going to go around and read in court, and definitely not like a detailed thing that you're planning to sort of read from. The idea of your notes is really more to support you whilst you're arguing in case you miss something, or basically to help you find the relevant pages that you want to show to the court or the relevant documents you want to show. So, my personal sort of system is I make two sets of notes. I make one note in which I sort of do a list of dates or a chronology of all the factual events which I keep, and then I make a separate note of the points that I'm going to argue, where I only lay down the propositions and the pages I want to show in support of that. But I'm not saying that's a foolproof system either. People use different systems. I know some friends who make all their notes in one page, some friends who make 10 pages of notes. Eventually, you have to find what is comfortable for you. But you need to work on it, is what I'm saying, because it does take some time, I feel, to come to a system that you are fully comfortable with. Another aspect here in this stage, that is before you get into court, is also deciding or sort of realizing whether you will need to file submissions in court or a list of dates. Now, I do not mean written submissions strictly in that sense. For example, written submissions predominantly in our system is filed after you have closed arguments. What I'm referring to is basically like a note or a list of dates which you hand over when you commence your arguments, to make it easier for the court to follow you and in a way to assist the court. Because realize this, that when you're in heavy matters or complex matters, there are several documents, several dates, several events that you will be highlighting to the court. The court has to sit and take notes. Now, if you can help the court by giving it a list of dates so that all the references are there and the judge does not have to sit and write everything down, but can just simplify it for him by giving him a list of dates where he can just make handwritten corrections or notes on that. It helps the court, and courts appreciate it. Doesn't mean you need a list of dates in every matter, but in bulky matters, in matters where there are a lot of dates, a list of dates is extremely helpful. One thing on drafting a list of dates or preparing a list of dates is it is something that you're going to hand over to court. So, in a sense, it is your submission, but it is based on the facts that come from the record. I feel that courts appreciate it if you can clarify that what part of your list of dates is based on the facts on record and what part of it is your submissions. Basically, in a sense, keep the list of dates neutral. It could be leaned in your favor, but do not make the mistake or do not try and show only a one sided picture, is what I would suggest. Because eventually you have to always answer the other side's case. And therefore, it is better to, and I think advisable also, that you put it down in a way where, so let me give you an example. You could say that maybe it is your case that on X date a meeting happened, whereas the other side denies that it happened. In your list of dates, you could probably say that 10th March 2019 meeting happened. Reference would be your plaint where you have said this. Below that, you could say note. The defendant has, however, denied this in its affidavit and said no meeting took place, paid so and so that the court gets a clear picture of the case going ahead. If you want, you could even further buttress it in the note by saying, but the plaintiff has shown this to show that there was a meeting, there is no denial, or there is no explanation to that. That is your argument. You could either do it orally, you could put it in the list of dates. The only point I'm trying to say is that try and keep it neutral so that when a judge reads it, he gets a flow of what the whole matter is about, including to a certain extent what the case of both sides is. It's not very helpful if you only give him one side of the picture and then say, now let the other side say what they want and I'll deal with it. At least show him what they want, what they're planning to say. Try and kind of buttress it to a certain extent in your note if possible. And one thing here, which I say for a list of dates or for any submissions you make in court, always value your word in the sense that the court goes by what you tell it. Never make the mistake of making a false statement or even an incorrect statement. And if you don't know something, say it. So, therefore, in your list of dates and things like that, you must be very careful that whatever you are saying is borne out by the record or is a correct paraphrasing of the record. Because if the court feels that you have tried to play smart, you will basically lose that court going ahead. So it's very important to be careful and to ensure that you value your own word so that the court can learn to value it eventually in time. Now, according to me, basically these are the broad sort of parameters or principles that you should consider whilst preparing for a case before you get into court. Now, bearing these principles in mind of anticipation and so on, let me go to the 3 or 4 different applications that we have identified as examples to show the practical aspects of how this works. So, the first thing was an ad interim relief in a suit or an interim relief in a suit versus a final hearing. Now, let us start with an ad interim or an interim hearing in a suit. Now, here, the most crucial thing that you need to understand, or for any lawyer while preparing to understand, is what is the goal of this ad interim or interim hearing? The goal or the purpose is to get you some form of interim reliefs pending the hearing and final disposal of the suit. Since In our system, unfortunately, laws delay or long time for final hearing of suits is a reality. Therefore, we need in several matters urgent interim reliefs which cannot await the outcome of the suit. But that is the test. Do you need these reliefs in that sense, or can they await the outcome of the suit? So, at this stage, really, you are preparing to show to the court that the 3 or 4 tests that apply to interim reliefs, which are well known, meaning in that sense, when you look at the substantive law on the subject, you will find that the standard tests in that sense are prima facie case, balance of convenience, irreparable harm and injury. You have to be in a position to show that all these 3 tests are in your favor. And you have to be able to also show that you have acted in an urgent and a diligent manner. So, really speaking, when you prepare, apart from preparing your case on merits, which is a part of prima facie case, you must also consider and bear in mind balance of convenience, irreparable harm and injury, and your own diligence and urgency. Because the court has to balance these factors. Therefore, it's very important for you also to consider and anticipate what questions may come on these tests when you go into court. Another aspect that you must consider, according to me, at the ad interim stage, especially when you're arguing interim matters, is an interim protection or an ad interim protection is, like I said, a protection which is given to you pending a suit. It is not a final adjudication. So, in a sense, what the court is doing is it is balancing equities. It is balancing your case against the case of the defendant, or if you are the defendant, it is balancing your viewpoint against the plaintiffs. So, sometimes asking for extreme reliefs or asking for a relief which you can only get at the final hearing of a suit may also be counterproductive. It depends from case to case, but principally always remember that the court is looking to balance equities. Therefore, in terms of your sort of preparation, when you're analyzing your case and you're thinking of anticipating what the court may say, what the other side will say, also think about how you would balance equities in a given case. What if the court were to ask you an alternate to your prayer in the form of balancing equities? Would that suffice? Would that be sufficient to protect your client? If not, then you must have an answer ready why a particular suggestion that the court is giving may not be sufficient and why you would need the full relief that you are claiming for. But these are things that you have to see case by case. But point being that the approach to getting ready is different at the ad interim stage, where you're looking at only identifying your prima facie case and showing why you need to be protected for a given point in time, as opposed to a final hearing of a suit. Now, in a final hearing of a suit, or let me even say a final hearing in an arbitration, basically the court or the tribunal is now called upon to see whether you have proved your case. So it depends, of course, firstly, in terms of the Evidence Act, on whom the burden of proof lay, whether that burden has been discharged. Therefore, in terms of preparing for a final hearing, your homework is that much more, because you have to go through, firstly, the pleadings to identify where a particular case was taken, then identify how it was denied, show the issue, show the relevant evidence on it, show the relevant documentary evidence that has been produced on it, marry it with the parole evidence and how the witnesses have dealt with it or how they have withstood cross examination on it, and then establish your case as having been proved or the other side's case as not having been proved. You have to be able to collate all of these aspects and then streamline and make it easy for a court to understand on a particular point as to how you have succeeded in proving your case. This is very different from what you would have done at the ad interim stage, where you would have gone purely by the affidavits that are filed by the parties and the documents and tried to show a court that you have a prima facie case that entitles you to be protected till the final hearing. So, in that sense, the idea is just to identify how, when you're preparing for these different types of hearings, you think differently, because the end goal or what even the court is considering is very different. And you must, in that sense, be preparing to assist the court for what it has to come to a conclusion on. Now, similar would be the approach when you go in for a writ petition. A writ petition, again, at the admission stage, normally you are seeking interim reliefs. So the court is again concerned with the question of whether you are entitled to interim relief till your writ petition can be heard. There is the question of maintainability that may arise at the admission stage. For example, whether your writ is maintainable, whether there is an alternate remedy. Now, these are all things you must be prepared for and you must be ready when you walk into that court. Because these are the questions the court is likely to ask you, or your opponent is likely to raise. Or if you are the defendant or the respondent, which you will want to raise, you will want to argue to try and defeat the writ. So you must, in that sense, to be able to anticipate some of these queries, you must have a grip on the substantive law and the facts. Therefore, I said that mastering your facts and having a requisite knowledge, I won't say mastering the law because personally I don't think that's really possible, but having requisite knowledge of the law necessary for your application that you're arguing helps you anticipate and be prepared for what to expect and what questions you may have to answer in court, which you need to be ready for. So again, at the interim stage in a writ or at the admission stage in a writ, questions of maintainability, protecting you for a time being, balancing of equities, just like sort of in an ad interim in a suit would arise. Whereas in the final hearing of a writ, the court is really not going to look at that, but is principally going to look at whether your rights have been violated, whether the parameters of 226 are established or 32. And it will then look at the pleadings and the documents and go on to give you an order one way or the other. So it's important to understand the difference in approach that a court has when you are arguing an interim application versus a final application. Sort of on the same vein or in a similar way comes the question of a second appeal. Now, a second appeal is slightly different, and I don't intend to pursue this again in terms of identifying interim versus final, but rather here I would stick to simply between admission and final disposal. The reason I say it is this: for a second appeal to be admitted, you need to have a substantial question of law that arises in your matter. At the stage of the admission of the second appeal, really the court is only looking at identifying the substantial question of law. It is only looking at identifying whether there is a substantial question of law which arises in your matter, which needs to be considered by the High Court. Whereas when you get to the final hearing stage of a second appeal, the court has to consider actually answering that substantial question of law. So even in terms of your preparation, in one, you have to show that the substantial question of law exists. I do agree that to a certain extent the research may overlap, but the test is at one stage, does that question of law, substantial question of law arise? At the second stage, it is a question of answering that substantial question of law. And therefore, the approach changes. The way you prepare, or if you were making a note or a list of dates or a written submission, again, the approach to them would change. The approach of how you would look to argue it in court would change. So that's sort of the factors you have to bear in mind. Similarly, when you come to bail applications, now I've just taken one criminal sort of application to sort of give a view even on the criminal side. Again, apply the same sort of, I won't say tests or principles, but apply the same sort of elements that I have been talking about, which is what is the judge going to look at? What is the other side going to argue? What is the substantive law as to the test that I have to meet to get bail for my client? And you will find that in the substantive law, there are several cases which lay down about 9 parameters that you need to meet, which was that you sort of need to be prepared on what is the offense for which you're seeking bail. Is it cognizable? Is it bailable? Is it under a special statute? Are there special conditions? What is the sort of status of your client? Does he come from an educated family? Is he likely to tamper with evidence? So you need to be prepared with all those tests. So in a sense, let me put it again on a similar anvil to what I've been trying to say, which is you need to know the substantive law to know the tests that apply when you're arguing a particular application. You need to then see how you answer those tests in your case and how the facts of your case give an answer to those tests in law. And you have to anticipate and be prepared how a court or the other side would look to distinguish or would sort of not agree with your points. And how would you counter if those kind of queries came your way? One last thing that I would add here is normally when you prep for going into court, always try and have a sort of backup argument, because you may think you're holding an ace up your sleeve, but there could be times where a court may disagree and a court may say that your ace actually doesn't apply in these facts and your facts are distinguishable, in which case it helps to have a backup. So if possible, see, facts come to us from the client, we don't create facts. So if some factual scenario doesn't exist in a case, you can't do anything to create it. But within the confines of what you have, always consider a backup plea if possible. And yeah, according to me, this basically should help you prepare before you get into court, because if you have done this stage correctly, then you are ready for whatever happens in court and you should be able to withstand and get through whatever is thrown at you in court. I hope I have been able to address and show some practical insight on how to prepare, which, like I said, my senior had told me is 90% of the battle. So, thank you. The one question that there is, would you encourage citing maxims, idioms, sayings, phrases to make argument in court or not? My answer to this would be sort of what I said earlier, that if you're arguing some simple proposition, or you basically just want to say that, look, I wasn't given a hearing, therefore this order must go. You may say that it's violation of audi alteram partem at the most, or you could just say that I wasn't given a hearing, it's violation of natural justice. But I do not advise for a simple thing going around citing maxims, idioms, because, like I said, the idea is to get an order, and the judge knows all this. See, always realize that a judge knows probably a lot more than you do, or even any one of us does. And he deals with these matters day in, day out. So he kind of knows the basic principles of law and he knows these basics. So, with respect to the basic stuff, I really do not advise it, because sometimes it comes across more as an attempt to show off rather than an attempt to sort of push your case along. Yes, on a given point, if you feel that your point you're arguing is not something which has been commonly argued, it's a very fine, nuanced point which the judge may or may not be aware of, then of course cite the idiom, the maxim, whatever it be. But basically, in a regular course, I wouldn't advise it. That's how I would approach it. Okay, the next question that there is what if the law behind case applies our case but the facts don't, does it still preferable? Okay, that the first attempt should try and be to find a case which is comparable on facts, which is similar, because then it's tough to distinguish it. If not, you could consider citing this and explaining why it would still apply in your case, because you would also realize that in terms of substantive law, there are judgments which say, or judgments which address the point of the precedent value of any case law, which explain and say that a judgment should be used as a precedent in similar facts, because even one significant fact could change the outcome. So sometimes, if there is a change in facts, it may really not help you to cite it unless you can show that it's comparable. So it's sort of a test every time to check whether you can draw an analogy. But if you're going to ask me, like, if there is a case on Copyright Act and can I cite it under patent law, probably something as extreme as that, I would just straight say no. But therefore, do the research, put in that extra hard work, and see if you can find something more direct. Moving to the next question: how to point out res integra in precedents cited by other side? I am not sure I understand the question, because res integra basically would mean that this position is no longer open in law, there is a judgment on it. So therefore, there is a precedent. So I'm not sure what the question is. If the question is how to distinguish the precedent, then predominantly on facts. You can see very often there will be very often the principle of law would be quite accepted. Of course, there are several areas where even on a question of law, there could be a conflict. Different high courts may have taken a different view, and that view may not have been settled by the Supreme Court. So you are always entitled to place the different viewpoints before that high court for it to consider. But supposing that high court has already taken a view, or the Supreme Court has taken a view, then you may really not be able to counter the principle of law which has been interpreted in a particular way. But you can always distinguish your case by going into the facts and by showing how factually your case is different. Because, like I said, even one fact can change how a particular precedent applies. So you can always check based on that and try and distinguish what the other side has said. One more question. If precedents are similar to the cases of law, would it be preferable to cite it in your arguments? Of course, meaning if you have a precedent which supports what you want to argue, definitely cite it. What if I said it differently, or maybe I wasn't clear? What I meant when I said earlier that be careful when you cite case law is this: a case law carefully, because you must compare to the facts of your case. Sometimes you will find that you may have read a particular point of law, but shows very different. This judge or the other side may actually flip the case on you and try and say that this judgment, in fact, supports me because of this one crucial fact. So, fact A was there in the judgment which is cited, but because fact A is missing, in fact, it supports what I am trying to argue. You don't want to hand over a judgment which supports the other side, which is why you got to be very careful when you cite. Be careful and then cite it if it supports you, because it, of course, it helps. The next question is views in different case laws on same issue. The test, as I understand the law on this subject, is that if the Supreme Court has different views, firstly, you will follow the view taken by the largest bench. So, if there's a bench of 5 judges which has said the interpretation of, say, a provision in the Income Tax Act is A, then you will follow that interpretation irrespective of what a 2 judge bench has said. But if a 2 judge bench, after considering the 5 judge bench, says that we believe what they meant or what they interpreted that provision to mean is really A, but in the sense of B, then you have to go by that. Here also the principle of per incurium, or being in ignorance of an earlier judgment, would apply. So basically you have to apply apply all those principles to see which is the sort of existing binding view. The other aspect also, sort of a precursor to any of this answer or the question is that you have to be unable to harmonize the views of the Supreme Court, because the first test always is to harmonize and to check whether all the views can be reconciled and lead to one sort of congruous situation. If not, then you get into applying these different measures or standards of determining which is the binding view. Thank you.